most consumers may be concerned about the leakage of the financial data. So that's why for open banking, we can see why the government, like UK government, US government, currently is trying to facilitate it, but still we need to be a little bit concerned about it. So we need regulation. That's why we have these regulations in the UK, where it first happened.
Can competition law actually protect the data protection in the financial market? What the EU has been doing and what the UK has been doing, I haven't really heard about the DMA, which really introduces some data protection within competition regime.
When it's a competition law would be the primary tool, and when should financial regulations lead, and when is the co-regulation be optimal. And such a framework I probably would guide policymakers and provide a theoretical contribution.
You want to compare EU, USA and UK, so I just want to ask what kind of method you applied for your thesis or your research? Only the empirical methods, or combine the empirical or doctrinal research for your thesis?
What really the data you're actually looking at? There are so many different data in the financial market, and is that only one particular or a few particular set of data can be dealt with competition?
How open banking can encourage fintech innovation, but also how a big tax entry may create new systemic risks, and exploring these dynamic elements would add depth to your proposed regulatory paradigm.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayat, for the immense work that you're doing in the GSN. And the Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, whole society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Naumanreayat.
Dr. Naumanreayat, the founder and convener of the Global South Network. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Reayat's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings?
So good afternoon, everyone. It's my great pleasure to welcome you all to this 48th seminar in phase 4 of the Interdisciplinary PhD in Progress weekly seminar series, organized by the Global South Network. Before we begin, I would like to extend my sincere thanks to Dr. naumanreayat, lecturer in law at Leicester Law School and the founder and the chief convener of the Global South Network, for his tireless effort in organizing and leading this inspirational weekly series that continues to bring together scholars and practitioners from cross-discipline and regions. I will start the session with some introduction. So, my name is Dr. Jing Wang. I'm associate professor in commercial law at Reading University, and my research is very related to today's presentation, which is competition law. I used to work in competition law and industrial policy area, and recently I'm more focused on examining the interface between digital anti-consumer practices and antitrust regulations in the EU, US, and China. And it's my real pleasure to chair today's Global South Network PhD in Progress session. I'm very much looking forward to hear about the presenters' research, their ideas, and the rich discussion that will follow. So I'm joined today by discussionist Dr. Chen and peer commentator Ruijue Gu. And Dr. Chen is a senior lecturer at the School of Law, University of Sheffield, and her past experience in working on the ESRC-funded projects are very related to the financial law perspective of today's presentation. And she used to working in the project titled Law Development and Finance in Rising Powers, as well as the project titled Informal Finance in China, Risks, Potential, and Transformation. Ruijue Gu is a PhD candidate currently working at the Leicester Law School, and her research is focusing on letter of credit. Finally, but definitely not the last, it's my great pleasure to introduce our guest speaker for today's seminar, Yingying Zhu, who is actually already passed her Viva. Many congratulations. And she is now started her first job as a lecturer at a top university in China. So her research interest includes merger controls in digital markets, competition law in China and the EU. And for today's presentation, which is partial of his PhD, is actually working within the area, bridging my research and Dr. Chen's research between competition law and financial law. So today's presentation is titled Competition Law Safeguards for Financial Data Sharing, an Open Banking Regulation New Paradigm. And she will speak for about 30 to 35 minutes, followed by 5 to 10 minutes of comments from the discussioners. And then we will open the floor for a Q&A session if time allows. Okay, so thank you so much for your focus for the introduction. And Yingying, we are delighted to have you with us today. The screen is yours.
Thank you. Thanks, Jing, so much for the detailed introduction about myself and about all of our commenters today. And it's a great pleasure to have a research topic that of relevance to your and to Ding's research. So, and also very appreciate Norman's, if there is no your organization, I can never have that, high level discussants here, including region. So thanks for everybody to listen about this presentation. So as Jin already introduced, my topic is about whether competition law in China can be a kind of way and can be the best way to intervene the data sharing in financial industry. So why I started to consider about this problem, I would like to do the structure like this to introduce a little bit about the background. So first of all, I would like to introduce why I will focus on the financial industry, not other industry. So in this part, I will try to figure out the sensitive characteristics of the financial data and also about the concept of open banking, like the current situation worldwide. Like in the US and EU, we currently have regulations on open banking, but in China, we do not have, and try to explore why we do not have and whether we need. If yes, then the problem is why competition law can be a kind of intervene. And you can see the second part somehow explain why we need open banking in China. Even if we do not have regulation, because actually we have some cases in China show we have abuse of financial data. So this is a kind of bridging the question and the follow-up competition law question. And for the first part, I try to figure out a potential way we can use competition law to intervene the financial data sharing issue. So this will be the structure of my presentation of today. And then, first of all, as I mentioned, I would like to introduce a little bit about open banking. So open banking is a concept we started in the UK. So I think it's very good to have a chance to present in lots of UK academia. So open banking is a kind of way that we can use our financial data as a consumer. We can share our consent, the banking, to share our data in between them. So if we use some terminology to describe this technology and this financial phenomenon, we can use the sentence I just flagged in the slides, which include we want to secure data sharing. Like individuals, you have the right to choose whether or not to share your data, and then the data sharing only limited to financial institutions and limited to financial data. And you can see these kinds of sharing we need. Sometimes we need this technology. Which technology it is? We need application programming interfaces, which we normally certified as APIs. So these kinds of terminology may be a little bit very difficult to understand from the terminology perspective. But if I give you a very simple phenomenon and example, maybe it will helps us to know this phenomenon, why we need open banking, why it's convenient, and why this is helping somehow the financial inclusion. So say after this presentation, it may be close to the time to have dinner. So all of us want to have dinner in one UK restaurant. normally, if we do not have open banking phenomenon, then what will happen if we have the bill? We will ask, like, everybody, we have our key card. Everybody has our bank cards, and we do the payment by one. But if we have open banking, say, Nauman as the organizer can just send the link to our like WhatsApp chat group, and all of us can just click the link and we can do the payment. And with these kinds of link, we do not even need to open our bank accounts. So it will be very convenient, you can see. So you can also see the other part of this phenomenon. Then most consumers may be concerned about the leakage of the financial data. So that's why for open banking, we can see why the government, like UK government, US government, currently is trying to facilitate it, but still we need to be a little bit concerned about it. So we need regulation. That's why we have these regulations in the UK where it first happened. So these are some kinds of, with this example, we can now try to explain the open banking steps and the process. You can see the first part is we need to have a customer decided to use these open banking services. So then we must have the consent from these consumers to do the data sharing. And then if these customers, they consent, what will happen next is their bank security also authentication page will be just pump up, and then this is a kind of to double check the consumer's consent, and the bank will verify the customer's identify and authorize when they are using these kinds of link to do the payment or to other financial things. And also these kinds of things, they are connected through APIs we just introduced. So you can see there are several steps, but between these steps, as I mentioned, the most important part is the sensitive of the financial data. And you can see with these kinds of potential concern that customers and the financial industry may have. So different jurisdictions worldwide currently or in the past have different attitude towards this open banking regulation, like whether we need it or even if we need it, in what way. So what kind of law or what kind of regulation we need. Then the UK is the first jurisdiction started to regulate open banking, and with these regulations somehow also in the other way facilitate the open banking development. And one point I highlighted is about the CMI order. So you can see in the UK, competition authority is one of the leading authority to facilitate the open banking regulation. This is one thing we want to highlight because it has relation to our competition law argument. And for the EU, although we do not have a competition law authority to do this, we still have regulations to regulate this, to facilitate it. And for the US, we not yet have API standards, but previously for US, it is a market-led jurisdiction, which means this open banking phenomenon, if two or three financial or laws or financial services companies, if they want to do these kinds of open banking, they can do bilingually, but bilaterally, but they cannot have a kind of very clear guideline what they can do and what they cannot do. So it means they normally depend on the market share and the assets and market power, it highly relied on these characteristics of different financial companies. So this is what a kind of market-led market or jurisdiction will have the problem. And then gradually the US fund for open banking, it maybe have some problem to develop like this way. So currently, it is trying to a little bit convergent with those of EU and the UK. So you can see for the UK and the EU, started with regulation, but for the US, it started with market-led, but finally found still need to rely on some regulation to do this, to give this market a very clear guideline. So this is the situation. And for China, still, it's currently a market-led jurisdiction because until now, we do not have any open banking regulation. And on the other hand, it's very rare because in all kinds of policy and government documents, we are continually trying to say we need to use our data, we need to encourage our data circulate, but still we do not have any regulation on how and in what way, to what extent in what industry we clearly can and should do these kinds of data sharing. So this is regulation differences and the market development structure. So I would like to classify the jurisdictions development way. So for the UK, EU, US, we call it as regulation-driven open banking jurisdictions. And for the China, I would like to classify it as market-driven open banking jurisdiction, because as we know, we still currently have somehow open banking phenomenon in our market. We have Alipay, we have WeChat Pay, these kinds of third-party financial industry companies, they have somehow data sharing consent from the banks. So you can see this development, these payments have somehow aligned with these open banking steps and process. They have consumers' consent, they have banks authentication, and also have banks verifies and connect through APIs. But you can see we still do not have open banking regulations. The problem is then, for these kinds, you can see now in China, we only have these third-party financial services, fintech companies, which are very somehow have high shareholders, high market shares in these relevant product markets. So these somehow are the results of the bargaining powers of these fintech companies, and also with these bargaining powers, consumers' choices somehow are harmed, because in theory, if this open banking, we have some regulations, then some fintech companies, they can also get these financial data through these APIs and do not need even to bargain with these banks. So this somehow reduce the consumer choices. So this is the problem I want to deal with. This is the main problem, I have to say. Like we can see have relation with competition law. So benefits of, like we explained, somehow we need open banking, and we have open banking regulations in 3 main jurisdictions, but we in China still do not have. Do we really need? Because sometimes for some markets, if the market development can just self-regulate, then we do not even need any regulation intervention. So this can be a kind of phenomenon. So we need to explore why we really need, because first of all, in this open banking phenomenon, once these consumers they consent, then we need to then our data are under control of these financial third-party financial service companies. Then how and to what extent they are using this sensitive financial data, we need some regulation. This is one thing. And for the other thing, you can still see have some relation to the previous point, like the security issue, like how these data can be protected. So we still need regulations. And the question is, competition law whether can do these kinds of thing to protect these consumers in this way. Obviously, we can see from this point, maybe no, because we are not doing this very in-depth to this personal data protection, but we still can see in this stage, do we can in this way to give other consumers, give our consumers sufficient choices as a kind of way to improve the privacy protection degrees or level, then in this kind of way, we can try to figure out whether there are other cases happen. So in this way, if we have competition law intervention, it cannot be very directly to deal with this potential issue about the data protection problem. But with this case repeated to be reviewed under whether consumer welfare are protected and whether the market structure, market share is protectedly is appropriate used, then we can start to find out a way to say potentially harm to the consumer welfare behavior. So somehow can help use this competition law case review to help the financial regulator to rule out these return provisions. So this is a kind of basic start point. And with this framework of our idea, we need to see why financial data is very unique and why we need to really share it. So for the first part, for why financial data is very important, we can see it can somehow build an accurate user profile, not only about one of your consumer behavior profile. It can be your up-to-date data, because every day you are using your bank account to do the transfer or to do the payment. So they are up-to-date, and these kinds of up-to-date data, it can be used in different locations than your location, and your somehow the salary can be inferred from your payment and your history. You use these kinds of payment history. So this is a kind of unique and the accurate and also the sensitive of the financial data. So we need to protect it. This is one thing very obviously. But still, with these kinds of sensitive, we can see it's very difficult for most third-party financial service providers to get. And these kinds of data, you somehow can promote the efficiencies of the market. So then the question is how we can balance this data protection and data efficiencies within this framework. So you can, we have the combination of different data can then lead to a problem. On one hand, we need it, and on the other hand, if these kinds of data, they are leaked, then the results, nobody can accept it. So this is why we somehow, in China, maybe it's not, we do not want to have an open banking regulation. We are a little bit only cautious about how we can do our best to protect these data, and meanwhile, we try to protect the efficiencies, because this is in relation to our financial law principles. So different jurisdictions from the financial law development perspective, we have different structure and mapping. So for China, our principle is we first try to make the financial market to be as stable and as safe as possible, and then we try to find out the efficiency and try to develop the financial market. So this is one of the potential reason why we do not have the regulation now. So we can see the data efficiencies, and we can see the benefits of the financial open banking, but we still do not have it. This is one of the reasons. So with this reason in mind, we need to explore to what, like we still need open banking, like we have the convenience, and we know we have the concerns raised by market-driven fintech companies. So why we always try to highlight the fintech companies? Because as we mentioned, the financial data, they have sensitive characteristics, and still these kinds of characteristics are different from other industry, because for most industry in competition law, for existing market participants, they normally have first mover advantage. But in this digital era, even if banks, they have much more history, and they have much more market shares in these traditional financial industry, but still for fintech companies, because of the data efficiency and the financial data, they are have up to date, and also can build the entire profile, including financial data and also other data of their customers. So they can just have overwhelm market shares and the market powers, even if they are not the first mover in the market. So these competition concerns raised by market-driven fintech companies, then it's about bargaining power and the consumer choices, which is mentioned in our table just now. We use as a kind of comparison between different jurisdictions. So we can see we still somehow need regulation, and we need the open banking. But when we do not have the regulation, why this market-driven model simply does not work? Because of this is some parts about the market power I already mentioned. So I would like to just move to the problem, to the case to show why we still can see without the open banking theories or regulations, we can see there are some competition law issues in financial industry, and these kinds of data sharing. We can see some market participants, they are abusing their market power in China, and there are interplay between the financial regulation and the competition law application. So this is a case about the bond transaction data. So the idea is for the upstream six bond issuance data collection. So these are brokers which they can collect their customers' bond issuance data. But the thing is, for these six brokers, because of the financial regulation. So if these brokers they want to have any dealing in the Chinese market, they need to get approval from the regulators. So this is somehow the regulation makes these markets participants are limited in these bond issuing data collection. So there are only 6 brokers. Then the thing is, they all have their own customers. So these bond issuing data, they are all unique because from different customers. Then the thing is, for the downstream customers, if they want to make the decision, they need to have the full real-time data, which is the full data set of the bond issuing. Then they need the data from all of the 6 brokers. Then the thing is, one of the upstream broker and the one of the financial information service provider in the downstream, they have an exclusionary agreement between them. The agreement said the financial information service provider can get the full real-time data of bond transactions from the upstream broker, and the upstream broker can never sell these kinds of data to other financial information service provider. So this is the exclusive agreement between the two. You can see the problem of this issue. From the case, you can see because of the exclusive agreement, there is a foreclosure between the two. Then these kinds of issue is because of the agreement, and the agreement we can see the competition law issue. And the thing is, in the decision, the Competition Authority of China only find the downstream participants and the upstream is not, but actually this is the result of the agreement. So the upstream, we finally, after the case, use the financial regulation to regulate and try to give the guidance of the following brokers to do this, to do this compliance in this phenomenon. But still you can see we need some, this case is a good example to see we have these kinds of competition law and financial regulation issue, and we have this financial data opening. They are the result of the market power, or they are the result of the anti-competitive effects. And finally, we can find some parts of the parties and some parts of the behavior. We need to use the financial regulation to start to regulate. And this financial regulation, the provisions, the design of the provision, they are have some theoretical similarity between the competition law and the financial regulation. You can see this from the Annex 1 of the financial regulation after the case, to say money brokerage companies should not abuse their special position to engage in data monopolization. So that's why I try to propose maybe competition law can be an intermediate way to see we have to regulate some parts of the open banking or data sharing cases, but finally, we still need to have financial regulation like other jurisdictions to do the regulate in this field. So thanks for the listening, and hopefully can get some insightful comments or all kinds of other critical thinking about my presentation, because I still want to develop it as a paper, but still I'm trying to figure out the best way to structure it, because it's a little bit difficult for me to try to make it very clearly between the two different law or regulations. So thanks.
Thank you so much, Yingying. This is excellent presentation, and we learned quite a lot, and making us think as well. So now may I invite Dr. Chen to comment on the presentation, please. Thank you.
Hi, thank you. Thank you for invitation, and thank you for the presentation. And so let me start with the congratulations and congratulations Yingying on completion your PhD and appointment. Thank you very much and for this very insightful and timely presentation. This paper addresses an important and fast evolving area, financial data governance within the context of open banking, and more specifically is the role of competition law, which can and should play in safeguarding fair access to financial data. But however, I didn't have the chance to read your paper, so all my comments are based on the presentation slides. And also I have to admit that I'm not, although I did involved in project which is mainly regarding fintech companies, in particular peer-to-peer lending, which already you have known that it's all kind of the whole industry collapsed in China, so it's no longer existed. And I'm not expert in competition law, so my comments is just hopefully that offers some my observation and some general comments. So first, I think you might want to think about to more clarify the role of competition law and to distinguish competition concerns from the data protection concerns. And from the slides which I've seen, and also from the presentation that you've given earlier, so I feel like that you kind of these two concerns are concepts are kind of being blended together. So you kind of keep referring data protection issues, and when you actually want to trying to justify the rule of competition law. So I think it would be probably helpful that for you to further distinguish the data protection concerns from competition law concerns. And also relatedly, so you talk about competition law cannot operate in isolation in financial sector, which is well taken. But also you might want to, in order to further establish this argument, I think you might want to further develop a clearer framework and of who should intervene and when. And for example, like you want to clarify when the competition law would be the primary tool, and when should financial regulations lead, and when is the co-regulation be optimal. And such a framework I probably would guide policymakers and provide a theoretical contribution. And also you might want to think about, so you in conclusion, you called for a balance between financial stability, innovation, and competition. So this is persuasive. But one additional avenue is to consider the dynamic competition and how open banking can encourage fintech innovation, but also how a big tax entrant may create new systemic risks, and exploring these dynamic elements would add depth to your proposed regulatory paradigm. So another sort of suggestion is probably that for you to further explore the cross-jurisdictional comparison. So you mentioned China, EU, UK, and US. So you might want to further to explore that further and to highlight how, for example, China's model, which differs in governance philosophy, and this might enhance international relevance of the paper. And I have also in relation to the financial, the concept of financial data. So I have some thoughts on this as well. So as we know, that the fintech firms, they also generate data, and also including scoring models that gives scores and based on. So this is pretty much the peer-to-peer lending is based on. And so how would we classify data created by third-party providers themselves? And this should also considered as financial data and for the purpose of competition law. And also, so should transaction metadata, for example, behavior patterns inferred from payments, and should be treated differently from the raw account data. So that's something I think probably worth thinking, and to clarify the concepts regarding financial data. So that is my short comments. And so, and in conclusion, I think this is a very thought-provoking presentation on a topic of increasing importance, and I very much look forward to see how this develops into a full paper.
Thank you so much, Dr. Chen. Would you like to respond quickly, or shall we move on to the peer commentator?
I just want to say very thanks, and because Dr. Chen gave 5 points, 5 comments, and I have to say all these 5 comments are very insightful, like make these distinguish between different legislations, and also how to explore more, like go one step further to use these comparison methods. So I have to say I buy all these points. So I'm so happy to get these comments, because I think this will help me to develop the paper much better. So I would be very happy to hear these insightful comments. And I have to say you must have do lots of things to prepare this. So many thanks for your time and for your insightful comments.
Thank you, Ying, and thank you, Dr. Chen. So may I now invite Ruijue for the comment, please?
Yeah, firstly, thank you so much for this very great and interesting presentation. Because my area is focused on the international transaction law, is focused on the letter of credit. So my research is not focused on the banking regulation. So I have a very little question, not focused on the content, but rather than the methodology part. Because during my research, when I also do the comparison research. So when I do my research, I just feel a little bit hard when I just do the comparison between the between the too many jurisdictions. Because in the very beginning of your presentation, you just mentioned you want to compare EU, USA, and the UK. So I just want to ask what kind of method you applied for your thesis or your research? Only the empirical methods, or combine the empirical or doctrinal research for your thesis? So my question is not very related to the content. Sorry for that. I just want to have this small question for the methodology part.
Oh, thanks for flagging this question. So actually, in my whole thesis, I applied doctrinal because case law is also a kind of method, but we know I'm not doing empirical because for empirical, it's very high standard. So if you want to do empirical from my understanding, we need to do exclusive analysis about the existing cases. So for the China and competition law, we may can, but for the EU, we somehow can use database, but still, I cannot make sure my selection of this terminology or these keywords are exclusive. So that's one way. Is the other reason is I previously have no experience in doing empirical research, so I'm not that confident about applying it. But still, I think if in your thesis it's helpful to do empirical, it may be much more convincing and much more accessible. But for me, doing this doctrinal research, the challenging part is I have to make my structure and my analysis convincing, and I need to apply these underlying theories. So also I need to find out my golden thread of the whole thesis. So this still have lots of challenging parts. Still, I think it also depends on the issue we are trying to deal with, because in my, for example, open banking points, we currently do not have any very authoritative cases. Although I cited one cases in slides, you can see, but that's only one. So we cannot do convincing empirical analysis. So we are trying to find out. That's why also have relation to the comparison. Like from the existing situation, like the starting point is we can see the differences between different jurisdictions. So I want to one step to one step, but hopefully, this is hopefully, but finally maybe from the presentation you can see this is not the thing, but still I try to analyze why these kinds of differentiation between these jurisdictions and try to flag these kinds of deviation of this one particular jurisdiction is because of the culture, because of the regulation, because of the industry policy, or because of the institutional reasons. So we can try to analyze, but doing this analyzation, still we do not have cases. We are trying to use these potential different theories. So still, that's why that led to my thesis developed to apply on the doctrinal research rather than the empirical methodology. So I think this is depends on the different research question, and then you gradually can find out different ways. But for some questions, maybe doctrinal and empirical, both of them make sense.
Thank you so much for the answer. Thank you.
Thank you both. And may I open the floor for questions from the audience? So my question is actually related to what Ruijue mentioned about the methodology, rather than saying for you to ask you to re-justify your methodology again. But I'm just thinking, because you mentioned you actually would like to turn this into a paper, and then potentially would be an article. So you actually opened with a comparative study within 4 jurisdictions. And my question is really about, is that too much for you to include in one paper? And yeah, so I would like you to start thinking about this, and then I will move on to the case you mentioned, that's one of the leading cases in China. Well, one of the successful cases, agency decisions for competition law in the digital market. So I'm just thinking, would that be a better idea to start with that case to justify the question, the problem? And when we're thinking about that question, the data protection perspective, I was thinking, is any indications actually being mentioned or being introduced in the EU or UK? I'm not quite familiar with US in this area. Is there anything that you'll be able to actually start thinking about, like, can competition law actually protect the data protection in the financial market? What the EU has been doing and what the UK has been doing, I haven't really heard about the DMA, which really introduces some data protection within competition regime. So I wonder, have you thinking of something related to the area that you already mentioned in China, and is there a relevant situation in China rather than in financial law? I would like to hear your response on that. Sorry, there's too much information being involved.
Yes, so I think for the first, I think you're right. Maybe I will buy that opinion. Maybe trying to think twice whether I need to have a different starting to posting my research question, because maybe it's much more easier, especially when the comparison does not make that much sense in developing my idea. So maybe I need to rethinking about it, and also rethinking the choice about the jurisdiction for comparison. So this is one point I would think twice. And for the second question, which is about the data protection in competition law, and the overlap between the data protection and financial industry. So this, I think, in relation to Dr. Chen's points, like maybe I need to distinguish the the data protection and the competition law application, because I flag too much about data protection that will make my readers or make my audience to start to a little bit confused about this thing. And as far as I'm concerned, I think you're right. There is no competition law cases, I think, in EU or UK are focusing on financial data issue. But then I started to think, is this because we have this open banking regulation in UK and EU, and then we can rely on this regulation to deal with these cases, so somehow they are prevented. But this is only one potential perspective, so I will still try to develop and to figure out it. Still, I think your point is really insightful. And for the last question, sorry, I
was thinking about, you see, in the DMA and in the UK DMCCA, there are actually provisions very specific on data protection related to competition issues. So my question is, do you actually thinking that would be enough for data protection in the financial market? So this would be something for you to thinking about afterwards, maybe would be beneficial for you to actually do a comparative study, because you see UK and the EU actually taking a different approach compared to China when we're talking about the digital market competition issue, anti-competitive issues. So would that approach be better approach compared to the China approach when we're regulating data, financial data? I'm only asking. I'm not really looking into the issue at all. So I'm only thinking based on what you have been discussed. Just something for you to further consider further.
Yeah, I think this is also insightful and also helps me to do the comparison to make the comparative research methodology to make more sense in developing my opinion. Because as you said, in EU, in the UK, we have digital market regulations about from the perspective of competition law, and then in China, we only have these provisions under competition law, but we never used it really to deal with these data issues, except this financial data one. But for this financial data one, we can only see the result. But from the analysis, the anti-competitive or effective assessment still have never mentioned about the data protection issue here in the case. So still, we can start to see the differences between these three jurisdictions. And yeah, you are right. So because of these kinds of differences ways, then we need to start to think whether these kinds of different ways, one of it can be drawn on in the other, or why the other one do not need to draw on, and then what's the next step for the jurisdiction that have faced with some issue in this area. So
Great, thank you. Yeah, I just want to re-emphasize Dr. Chen's point about the data. So what really the data you're actually looking at? There are so many different data in the financial market, and is that only one particular or a few particular set of data can be dealt with competition law? Okay, so I think we are run out of time. Am I right, Norman?
Yeah.
Okay, so thank you everyone for all the contributions, and thank you so much, Yingying, for your insightful and stimulating presentation. We definitely see the valuable contribution actually already being made into the area, and we appreciate everybody's discussion. So thank you so much for Dr. Chen and Ruijue for your contribution, for the feedbacks that's going to help Yingying to further develop her research. And towards the end, I think I would love to thank Dr. Norman for the opportunity to invite all of us to have an insightful discussion about the evolving areas of law. And the Global South Network warmly welcomes PhD students from all disciplines and from every corners of the world to share their research and receiving interdisciplinary feedback. And from my own experience, I definitely see the beneficial of presenting at this platform, and I can see my own PhD students benefit a lot from discussion as well. So really thank you for hosting this event, Norman, and I would love to thank everybody again for your contribution. So thank you so much and goodbye.
Thank you, everyone. Bye-bye.
Thanks, Jing, for actually chairing the session. Thank you.
My pleasure. See you then. Bye.
See you then.